Well, welcome back. Hopefully you had a nice lunch, and we're going to now resume our program with a special kind of panel. This is not quite the way we had the first panel set up. This is actually intended more as a presentation of slightly differing viewpoints on an important topic, which is the balance of protecting privacy and security together and getting the right set points. And this has certainly been something that's been in the news over the last, certainly over the last year, less than year. Some of it brought particularly to the fore by some of the exposures of information by Edward Snowden and the fallout from that about federal collection and use of telephone metadata. And that is going to be central to this discussion. I'm not going to go through and go into depth in the introductions on our two panelists. They're both very eminent in areas of the law as it applies to security and privacy. We have immediately to my left Mark Rash, who's the Chief Privacy Counsel for SAIC. He's had a career as really one of the first federal attorneys for prosecuting computer crime. He's gone on from there to be an advisor and in a number of different organizations. He's served as a law professor at several universities, including the American University, Harvard, and others. He's been very notable in the scene for issues of security and privacy, arguing a number of different points of view, as he will today. And then to his left, David Medin, who's the chair of the Privacy, Civil Liberties, and Oversight Board, which was set up by Congress with statutory authority for oversight of intelligence and privacy issues as they relate to terrorism and anti-terrorism in the United States. Before that, he had a long career, distinguished career, working as an advisor for federal agencies, primarily in the consumer arena, as you can see the list on his bio, helping to craft laws and regulations protecting privacy of consumers. And if you follow it back far enough, he was a Hoosier for a while, serving on the faculty of the law school at IU Bloomington. Both of these gentlemen agreed to come here, and again, this is not a point-counterpoint. This is not, they're opposed. They're going to illustrate two perspectives that are common, supportable, having to do with the use of collected information by the government for purposes of anti-terrorism. And the format of this, each is going to speak for 20 minutes, then each will have a 10-minute follow-up, and then we'll open it up to any audience questions if any of you would like to join in. So, who won the coin toss?
You did.
Mark did. All right, thank you.
Thank you, Gene. I have to stand because I'm a litigator and I'm used to standing, so you'll have to excuse me for that. I also wander, so. I want to talk about how we got to where we are today, to lend a little bit of perspective to this before we jump into what the world looks like today. So for the first, say, 200 years of our nation's history, if the government wanted to engage in espionage, in spying, in data collection, either on U.S. citizens or on foreign nationals, we just did it. Okay, and this started from the beginning of our history. We've been engaged in espionage and spying and collection. All nations do it. It's an inherent right of sovereignty. We have the right to do it. And with the invention of certain technologies like the telephone, we had a little difficulty about trying to apply the concepts of the Fourth Amendment to new technologies. Now, the Fourth Amendment doesn't say what you think it says. All right? The Fourth Amendment says the right of the people to be secure in their persons, places, houses, and effects against unreasonable searches and seizures shall not be abridged, I think. And then it says, no warrant shall issue except upon a finding of probable cause issued by a neutral and detached magistrate specifying the place to be searched and the thing to be seized. one would read this as saying, wait a second, you have to have a warrant to engage in a search or seizure. It says, no unreasonable searches and seizures, no warrant except with a finding of probable cause. That's the way I read it in law school. That was before I started prosecuting espionage cases. And I learned that those are two separate clauses. In fact, the vast majority of searches and seizures conducted in the United States are done without a warrant. Right? So let's start with that. Most searches and seizures are done without a warrant. In 1923, the Supreme Court, in a case called Olmstead, found that you don't need a warrant to listen in on somebody's phone calls. As long as you're not trespassing to install the twisted copper cable, the alligator clips, you don't need a warrant. Why? Because the Fourth Amendment says no unreasonable searches and seizures. And when I put alligator clips on your phone, particularly if I go to the phone home office to do that, I haven't searched for anything, I haven't seized anything. I've listened in on a phone call. And that was the law pretty much continuously. And so when President Roosevelt wanted to listen in or have the OSS listen in on phone calls into and out of the United States and within the United States for national security purposes, he simply tasked Wild Bill Donovan to do it. Wild Bill Donovan reached an agreement with the phone companies and the telegraph companies, and they monitored all the communications that they had the technical ability to do, both into and out of the United States and domestically, provided they were related to national security or foreign intelligence purposes. This was the state of the law under a president by the name of Richard Nixon, who somewhat redefined the concept of national security and foreign relations to include political matters. And as a result of several things that were revealed about the Nixon administration, including those by the Church Committee, by Frank Church, Congress tried to take back some of this authority. So up until the Church Committee, basically it was executive power by executive fiat alone. So Congress created something called the Foreign Intelligence Surveillance Act in 1978. And the Foreign Intelligence Surveillance Act was intended to create in the foreign intelligence and national security arena a reasonable facsimile to what we have in the criminal arena. Now remember when I described the Fourth Amendment a minute ago, we said the right of persons to be secure against unreasonable searches and seizures shall not be abridged. That's one clause. And then it says no warrant shall issue except upon a finding of probable cause issued by a neutral and detached magistrate, a separate clause. Now, the problem with applying the warrant requirements to national security matters is that no warrant shall issue except upon a finding of a probable cause to believe what? Traditionally, we've thought about probable cause as a requirement that the court find probable cause to believe a crime has been committed and evidence of that crime will be found somewhere. So to search your house, not that you committed a crime, but somebody committed a crime and there's evidence of that crime at your house. To listen in on your phone calls, the same thing. To engage in surveillance, the same thing. Some forms of surveillance, all right, the same thing. Well, how do you apply that concept of probable cause, which is a criminal concept, in a civilian arena where you're doing national security? It's not probable cause to believe a crime has been committed. It has to be probable cause for something else. And in establishing the Foreign Intelligence Surveillance Court, what Congress tried to do is rein in the unfettered power of the executive and create something like judicial review and judicial authorization before you can engage in these national security type wiretaps, particularly within the United States. So what it basically said is, if the executive branch wants to engage in surveillance in the United States, do what they call black bag jobs in the United States, search, seizure, that kind of stuff, primarily in the United States or targeting U.S. persons, it has to get a warrant. But the warrant isn't for probable cause. The warrant is upon a certification that it is relevant to the national security, foreign relations, or intelligence gathering operations of the United States. It was supposed to work very similarly to the way it works in the criminal arena. The government goes to a court, which is a top secret court in a top secret location on the 5th floor of the Justice Department, room 5116 on the northeast side. It's not there anymore. Used to be there. And I made the number up.
It's in a classified location now.
What?
It's in a classified location.
It's okay. I made the number up anyway. But it was on the 5th floor of the Justice Department, which was not classified. They go to the court. They make a presentation ex parte on their own, explain what they want to do. We want to put a wiretap on Vladimir Kodinsky. We'd like to do it for this period of time. The court approves it. You put the wiretap on. You do the surveillance, and that's how it works within the United States. And you have to not deliberately target a U.S. person. U.S. person, by the way, is a broader definition than U.S. citizen. And those were the controls that were placed on the collection of information. And the reason that was necessary is because in the absence of the FISA court, there was no mechanism for the intelligence agencies, once you said we're eliminating your unfettered discretion, there was no mechanism for them to get judicial review. So we created this top secret court. That lasted from 1978 until 2001, when the September 11th attacks occurred. And there were all kinds of limitations on what you could do with national security wiretaps and data collections. After 2001, we fundamentally altered the rules of the FISA court. And these were subtle changes to the rules about the FISA court, which have profound effects. One of the changes was in Section 215 of the USA Patriot Act. We now allowed the FISA court to issue orders for the seizure of documents, records, and physical objects. Now, before we get outraged by this provision, which is what all the debate is about, your average divorce lawyer has the right to subpoena documents, records, and physical objects. All right? If you get in a car accident on Main Street here, the lawyer representing you has the right to subpoena documents, records, and physical objects. It is not unusual. Every prosecutor in America has that authority. Every grand jury has that authority. Every lawyer involved in a civil or criminal case has that authority. Almost every administrative agency has that authority. So granting under Section 215 the authority to the NSA to issue granting the government the authority to request of the court an order for the production of these records is hardly unusual at all. All right? Second thing is, the National Security Agency was created for the purposes of engaging in, shockingly, spying. That's what they do. That's what they're supposed to do. That's what they've been doing ever since they were created. Before they were created, the OSS did it. Before that, there were various agencies and departments. We've been engaged in spying on our enemies since the creation of the Republic and even before that. So we shouldn't be shocked or offended that the government is engaged in spying. So two things. Spying is a normal and inherent part of national sovereignty. And we have these controls implemented through the FISA court to attempt to mirror what we do in the criminal arena, where we apply to the court, we get a warrant, the order allows us to do the search and seizure. Now there's a third thing that happens at the same time within the Fourth Amendment. And that has to do with a fascinating little case of very little importance, which has fundamentally altered the landscape for the Fourth Amendment, particularly in the national security arena. And it had to do with a woman who was mugged in downtown Baltimore. This woman was mugged in downtown Baltimore, and the assailant stole her purse. Within a few days of her purse having been stolen, she starts getting phone calls. Apparently, she had her phone number in her purse. on her landline phone. Does anybody remember landline phones? So she starts getting these telephone calls, harassing, threatening phone calls. And the person who calls her tells her he's been following her and driving around her house. So she notices this car driving by her house. She calls the police. The police stake out her house and see the guy drive by. They write down the license plate. They go check the license plate number, and they get the name of Mr. Smith. That really is his name, Mr. Smith, who was the guy driving, who was the registered owner of that car. They look up, and Mr. Smith lives at a particular address not far away and has a particular phone number. They go to the phone company with a subpoena. Subpoenas are different than search warrants. They go with a subpoena to the phone company, and they say to the phone company, we would like this guy's phone records for the last 3 or 4 days because we want to see if he called her. They get his phone records. Lo and behold, he's the guy who's been calling her. Does anybody here think that the actions of the government in that case were outrageous and unreasonable? Okay? Does everybody think that the actions of the government in that case were perfectly reasonable? Does everybody here have their right hand paralyzed? All right. So the Supreme Court was faced with this decision in a case called Smith versus Maryland, in which Smith was prosecuted, and he claimed, hey, wait a second. These are my records. You're searching and seizing my records without a search warrant. And what the Supreme Court said was a multi-part decision. They said, first of all, you're wrong. They're not your records. These are the phone company's records. These are the phone company's records of how you use their service. They aren't yours. You have no expectation of privacy. Second of all, they are not content information. They're the fact that you made a phone call. BFHD, big, fat, hairy deal. Who cares? It's not that important. This doesn't reveal intimate personal details. This is not content information. Third, you consented. You know that when you make a phone call, there's a record that you made the phone call. You don't like it? Tie 2 Dixie cups together with a string. Fourth, they said, you trusted this, you voluntarily gave up your privacy when you entrusted this data to a third party. So it's not your data, you consented, you voluntarily entrusted it, and it's not intimate personal details. It's non-content information. And therefore, what the government did was perfectly reasonable. Okay? That's hardly a surprising decision. You should read, though, if you read Smith, take a look at the dissent by Justice Marshall, Thurgood Marshall. And what Thurgood Marshall says is, consented, on what planet did you consent? I'm paraphrasing. He said, phones are a necessity of modern life. It's not like you can choose to use a phone or not choose to use a phone. There's no element of consent here. All right? And he hinted at this concept that by analyzing people's phone calls, you can learn a lot about them. Okay. But Smith versus Maryland is the law. Now we take these two things. One, the ability of the NSA to obtain documents and records under Section 215 of the USA Patriot Act, and the holding in Smith versus Maryland that you have no expectation of privacy in records held by a third party. And we give those two concepts to the NSA. Now, let me give you an example of how the NSA might use this information. A raid is conducted in a cave in Afghanistan, and a cell phone is located. And that cell phone was used by a suspected terrorist to make telephone calls into the United States. We find the phone number that that terrorist called to. And we want to be able to track the phone number that was called to. We want to know who owns that phone number, where did that phone number call to immediately afterwards or beforehand, who's associated with that phone number. Not every phone call, but relevant phone calls from that phone number. Say 1 step, 2 steps down. Okay? The problem is, right now, in the absence of some technology, that phone number might be an AT&T phone number. The numbers called by that number might be a Sprint number, might be a US cellular number, maybe some other provider. There is no efficient mechanism there's no unified database I can ping to get those phone numbers, to analyze those numbers, to get the information that I need. So, what the NSA did, according to the classified records provided by Edward Snowden, which I cannot comment on its accuracy or not, but for these purposes we will assume to be correct. What the NSA did is they essentially said to the phone companies, we will take custody of the non-content telephone records. We will put them together in a way that makes them searchable. Then we will apply to the court for an order allowing us to, if we meet certain parameters, conduct a search so that we can find out what calls were made by numbers, and we will not target US persons. That was the program that is called the Call Record Collection Program. Now, there's a lot of matters about it that are still classified, but that program is relatively narrowly tailored and used primarily, and I can't say exclusively, but primarily for the purposes of conducting national security and terrorism investigations. And we start with the assumption that there is no easy technological way currently to do the same thing without taking custody of those records. So that's the program. It has been approved by Congress, both when they applied for and enacted Section 215. Congress has been briefed on the program, at least the intelligence committees, and approved it. It requires judicial oversight and various levels of oversight within the NSA and the Justice Department. And that's essentially setting the stage for, that's the program we're talking about. And the question is, and this is more of a political debate than anything else, is it legal, is it appropriate, and does it really protect national security? And I'll take the government's word that it's intended to protect national security, although there is some debate as to whether or not it makes a difference to be able to track a phone number in a few hours or a few days, and whether or not we necessarily have to do that. That's part of the debate. But that's how we got from where we were before 2001 to where we are today. All right?
Thanks. David Medina again. And Mark did a great job setting the stage. I'm not a litigator, so I will stay put. First, a minor disclaimer, which is a standard government, which is that my comments today don't necessarily represent the views of the Privacy and Civil Liberties Oversight Board, which I chair, or its members. They are my own views. Second, while I'm going to critique some of the programs that NSA is involved in, I want to make it very clear that in all the work that I've done and our board has done, we have nothing but the highest regard to the dedication of people in the intelligence community. They work tirelessly to protect us, more than I think people know, and we've seen nothing but good faith. And so we have some disagreements about some legal and policy issues regarding the programs that they carry out, but they are an extremely dedicated group and have highest praise for them, and I want to make that very clear. Just a little bit of background about our board. After 9/11, as you know, a 9/11 commission was created to analyze what went wrong and what we could do in the future to prevent terrorist attacks. And if you haven't read the 9/11 Commission report, I highly commend it to you. It reads more like a novel than a government report and detailing everything that went on. But after about 500 pages of saying we need to collect more information about terrorists and we need to connect the dots better than we did before, at the very end, in about 2 or 3 paragraphs, they say, but by the way, if we go too far down the road towards protecting against terrorists and forget privacy and civil liberties, we've lost what makes us a great country, and we lose a lot of our values and don't necessarily create good security. And they took the position that you can have both national security and privacy and civil liberties, and a position that President Obama has reiterated in the last year or so. And so they recommended the creation of a board to advise the government, the president, and Congress on how to strike the right balance between privacy and civil liberties and national security. And a board such as that was created initially as a White House entity under President Bush. And the White House felt that because the board was sitting in the White House, that the White House was free to edit the board's materials. And one of the board members resigned in protest and said, we're not sufficiently independent to express our views. And Congress actually followed up on that and abolished Privacy and Civil Liberties Oversight Board version 1.0 and created what we are now, which is 2.0, which is still an independent agency in the executive branch. We're a 5-member board. We're bipartisan. No more than 3 members can be any political party. And independence is a critical feature, and I'll discuss it in a moment. But there's an understanding with the White House and us that there's no prior review required of our views. That is, the OMB, the White House does not clear any of our legislative testimony, our positions that we take, our reports. We are truly independent. But at the same time, we have highest level security clearances, and so we have full access to intelligence programs, so we understand what's going on. So just in my personal background is I was nominated for this position in December of 2011, and it took the Senate 510 days to confirm me, but perhaps they knew something because I started work 4 days before the Snowden leak. And we had, at that point, no email system, no website, not really an office, and 2 detailees as our entire staff. When the Snowden leak occurred, we were asked by 13 senators and the president to investigate the telephone metadata program that Mark described. And so we undertook an investigation. Let me just, as an aside, our board has 2 functions. One is oversight of existing government programs, and the other is to provide advice to the government as new programs are developed so that privacy and civil liberties are taken into account. With regard to the 215 program, we exercised our oversight authority. And under that authority, we have full access to government information and government personnel. And if we don't get it, we're entitled to go to the head of the agency and tell them to order their staff to provide information to us. We found to date we've had complete access to everything we've requested in terms of documents, court decisions of the secret court. We've had unredacted from the beginning, briefings from high-level government officials. And so we've had as much access as we could possibly want to get a better understanding of how these programs operate. I should also say, should we ever need information from the private sector, we have the authority to go to the Attorney General of the United States and ask that a subpoena be issued on our behalf. And the Attorney General has to either issue the subpoena or explain why the subpoena isn't being issued. To date, again, we've gotten a lot of cooperation from the private sector and haven't had a need to exercise that subpoena authority, but it is always there if it's required. So starting last summer, we started investigating the program that Mark described, the, again, telephony metadata program, where the telephone numbers are recorded and collected by the NSA, but not the contents of the phone calls. It's the time of the call, the length of the call, and the phone number, and some other information, but most importantly, not the contents of the call. And we had, again, lots of briefings and to get a better understanding of the program. And ultimately, as we looked at the program, we evaluated it from 3 perspectives. One is it legal under Section 215 of the Patriot Act? Is it constitutional? And Mark sort of laid the foundation for the 4th Amendment constitutional analysis, and there's also a First Amendment analysis as well. And putting aside legality and constitutionality, is a good policy? Does it strike the right balance between national security, privacy, and civil liberties? Without hiding the ball, what we concluded was no, and the program should be discontinued. But let me tell you how we got there. In terms of the legality of the program had been going on without legal authorization for a while, and sort of what seems to be the pattern in this area is a program goes on, as Mark said, sort of the president exercising constitutional authority, and it gets leaked, and there's a lot of uproar, and then there's an effort to put it under some statutory authority. And so in this case, when this program was leaked, people looked around for the right legal authority to put it under. Might have been better to go to Congress for fresh authority, but instead they sort of looked on the shelf and said, what's here? They said, the business records program, let's put it under that. And that's a program that was really designed to get specific records about specific people under specific circumstances. And this program, the telephone metadata program, as Mark described it, is we collect phone records all the time from lots of people in the country, hundreds of millions of people, and then as needed, we search that database. That's a very different concept than going out and getting records of a particular transaction. But they chose that statute, I think somewhat unfortunately, because it was not a very good fit for a number of reasons. One is the statute requires that the information collected be relevant to an investigation. And the problem is your records, my records are, I hope, not relevant to a particular terrorism investigation, and yet the government was collecting them under the theory of relevance, which was if we create a system that allows us to analyze the information to find terrorists, therefore all information that could possibly be used by the system is relevant. And that, at least the majority of our board's view, and I'll explain some of our splits, was not appropriate interpretation of the term reasonable and relevant. There are a number of other statutory problems. Under the statute, it calls for the FBI to collect the information. As you know, the NSA is collecting the information. That's not a trivial distinction. The NSA, as you know, is supposed to be directed toward foreign intelligence. The FBI is for domestic, and this is domestic calling information. And the FBI has certain procedures to protect information that the statute contemplated would be provided here. And yet, again, we have the NSA and not the FBI collecting the information. We also have a law that says, the Electronic Communications Privacy Act, that tells telephone companies, don't give your information out to the government except in these very limited circumstances. Section 215 was not one of those limited circumstances. There are other government authorities that could have been used to get the information, but not Section 215. So for a number of reasons, we felt that this statute was not a good match. And at this point, I should indicate we're a 5-member board. At the end of the day, 3 of the board members, including myself, adopted the analysis that the law did not justify the program. 2 of the other board members who wrote separate statements felt that there were reasonable interpretations that would allow the law to apply in the situation, and therefore they would have given deference to the government. So that we only split on 2 of 12 recommendations, but one of them was related to the legality of the program. So again, we had some legal problems. On the constitutional side, as Mark indicated, Smith v. Maryland is the law of the land. We have one person who was suspected of a crime, whose phone records were collected in a very primitive way based on the technology that was available for a limited period of time. That is wholly different from everyone in the country's records potentially being collected ongoing basis without any suspicion of any particular criminal activity. And so, yes, Smith v. Maryland is the law of the land. Yes, we think it was appropriate for both the courts and the government to rely on it. The question is that going to continue to be the law of the land? We actually had the lawyer from Smith v. Maryland who argued the winning case for Maryland, saying no warrant was required, come talk to our board members. And he said, I can't believe this little case was the justification for this entire NSA program, and I hope my legacy doesn't go down supporting that. Because he argued to the Supreme Court, this is a very narrow circumstance, a very small set of facts. In any event, there have been subsequent case developments that at least some people think suggest the Supreme Court may revisit this issue in the future and not necessarily view Smith v. Maryland as the law of the land. As many of you may know, there's the Jones case involving GPS tracking, where members of the court indicated that they might cast some doubt on the notion just because a third party holds your information is not subject to the Fourth Amendment, because maybe back in even the last century, that wasn't a big issue. But today, the private sector holds all of our information. And if we take the notion that the government can access everything that's held by the private sector, that gives the government a lot of leeway. And so at least
and hinting at the distinction between content and non-content information as well in Jones.
Right. By the way, on that point, I should add, there's a lot of discussion as to whether metadata, just telephone calling records, is sensitive information or not. Some would argue it's just numbers. We don't know who it is. We don't know what's going on. But the reality is, once you know who's calling who, you know a lot about people. You know about their you can determine and infer their medical conditions. You can infer their political affiliations.
And that's where the First Amendment argument comes in as well.
Right. If you're a source for a journalist, you might be reluctant to call the journalist and have an off-the-record conversation, background. If you know the government now has a record, perhaps if you're a whistleblower, calling a journalist that you've now called. You can imagine in a religious context, in a political context, if knowing that the government is constantly monitoring your communications, or at least has them available to review, even if no one is looking at them at the moment, can have an effect. So I guess on that point, I'll touch on the First Amendment. None of us have said that this law violates the First Amendment, but it certainly raises some significant First Amendment concerns for the reasons I just stated, which is knowing that the government has that information available to it can chill your exercise of free speech, free association, freedom of religion. And so, yes, the government has a very legitimate national security purpose for collecting this information, but the question is there a narrower way of doing it? And I'll talk about that. I think there is one. Likewise, in the Fourth Amendment, we didn't come to the conclusion it was a violation of the Fourth Amendment. We just said that there are a lot of concerns raised about this type of search, and the law may be changing, and that, I think, can inform the policy debate about whether this is appropriate. And so that turns, I guess, to the next part, which is moving past the legal and constitutional side as a policy matter. Is this program collecting telephony metadata a good idea or not? And so we looked at two things. We looked at the national security side of the equation, and we looked at the privacy and civil liberties side. And on the privacy and civil liberties side, as I've discussed, it really is significant the government's collecting everyday transactions. It really shifts the power between citizens and the government, again, potentially chilling rights. There are people who already have said that they are not willing to do certain activities knowing that the government is collecting this information. But also, national security is very important. And again, we're not an advocacy organization. Our life would be a lot easier if we could just advocate for privacy and civil liberties. We have to actually try as best we can to strike the balance between national security and privacy and civil liberties. So in order to do that, we took a very hard look at the efficacy of the program. And as you may know, the government has advanced a dozen instances in which it felt that the program made a significant contribution to national security. And so what we did is we took a look at each of those examples, got access to classified information supporting the examples, did a factual analysis, and we even gave the factual analysis to the intelligence community and asked them to verify that we got the facts right, and they made some minor corrections, which we adopted, and so we were on the same page. And what we concluded was the program had very, very limited effectiveness. One is, it's never, and again, this should not be the only criteria in our view, but it's never thwarted a plot. It's never identified a terrorist that we didn't know about previously, which are certainly some high water marks. But we view efficacy as far more than just those two criteria. We also looked at the peace of mind component, which is sometimes it's helpful to know there isn't a plot underway in the United States. That is, nobody called in from offshore about a plot, because that way we can deploy the FBI to do other types of activities. So there are a number of potential uses for this information, but the only example where the program was clearly effective was a material assistance case where someone in the United States was sending money to a terrorist organization offshore. Is that an important thing to stop? Absolutely. But we felt that on balance, it didn't justify the continuation of this program on the efficacy side because there are other tools available to the government, particularly with regard to peace of mind and thwarting plots, that leads to the conclusion that the program isn't sufficiently effective. And so, again, balancing the privacy and civil liberty side, which were significant, versus the national security side, where we felt the program wasn't that effective. Again, the majority of the board called for the elimination of the program. And the question is, okay, so what's the alternative? And what we proposed is that other legal authorities be used to gather the information directly from the phone companies. There are, and you're all technologists, so there are technologies that allow you to search multiple databases and with close to the effectiveness, and maybe a little bit longer, but close to the effectiveness you can get from searching one large database. And so we recommended after an interim period, the abolition of the bulk collection program and reverting back to the phone companies. And as some of you may know, just this morning, the President of the United States called for just that, which is that recommended that the bulk program be ended and that the phone companies be the source of the information. And the President this morning proposed that there be legislation adopting exactly that approach, not imposing any additional record-keeping requirement on the phone companies, which currently under FCC rules have to keep the information for 18 months, but just codifying that so everyone is clear about that, and going forward on that basis. And so it's an example where there's an important national security concern, but it can be met in a less privacy and civil liberties intrusive manner, again, by not having the government collect all the information, but keep it on the private sector side. And so that's where we came up. I should also add that Mark touched a little bit on the Foreign Intelligence Surveillance Court, and a lot of the arguments were made, well, this court has always approved this program. Who are we to come in and raise questions about it and come to a different conclusion? And one of the things that we learned is that, and as I think people know now, the court only hears from the government. And judges told us, we actually heard from judges, former judges of the court, who said, we actually like to hear both sides of the argument before we make our decision. And you hear one side, it sounds pretty good, then you hear the other side, it sounds pretty good, and then you have to work it out. In this case, the judges only heard from the government, so they never had the benefit of opposing arguments. And so we've recommended that in the future, there be a panel of outside lawyers, private lawyers who are brought into significant cases, who can argue that there are legal and constitutional issues and let the judge grapple with both sides of the argument. And again, that's an approach that has been adopted by the president, and many in Congress are also moving in that direction. And then the last thing we focus on is transparency. I think one of the lessons here is that we're having such a heated debate about these issues because nobody knew, or many people did not know they existed. And also the legal authorization wasn't clear. So again, the majority of our board felt that in the future, laws we enact to create surveillance programs, even if they don't give the specifics of the programs, which would thwart their effectiveness, there should be clear that there's a broad grant to collect bulk data or to do other kinds of government activities. And so we'll have, as a democracy, have a debate about whether that's an appropriate grant of authority. And again, one example of that is a program that we're now looking at the board, which is the so-called 702 program, or PRISM, or Upstream, where we haven't reached any conclusions, but certainly a lot of people believe that was a much clearer grant of authority. Very few people were surprised to learn what was going on based on the legislative debate that took place. And so that's an example where we can be transparent in legal authorities without necessarily giving up sources and methods that might undermine the effectiveness of a program. And so with that, I'm happy to
Yield the balance
of my 20 seconds to Mark.
I'll take those 20 seconds. All right. I'm going to stand up again because I'm still a litigator. I just want to touch upon the consequences of trying to shoehorn this program, the telephone metadata, and I don't even call it telephone metadata. The civil libertarian in me calls this the, what does the FCC call it? I'm trying to remember. CPNI, Consumer Proprietary Network Information, okay? See, one of the things that happened was that the FCC proposed rules and adopted rules for phone companies about what can happen to the data. So after Smith versus Maryland, the FCC essentially issued rules that said, wait a second, phone companies, this isn't your data to do with however you want. You can't sell it. You can't use it for other purposes. You can't provide it to other people. You can't make it publicly available. It's not your data. There are significant privacy-related restrictions on what you can do with CPNI, or what the phone company calls, what the NSA calls metadata. The second thing about metadata, which really was not discussed in adopting this program, it's startling to read the Department of Justice's Office of Legal Counsel's memos on this. They just took Smith and said, Smith says we can do it, no problem. And there was never any real discussion on the impact of it. There was a Supreme Court case called NAACP versus Alabama, where the state of Alabama wanted a list of the members of the NAACP of Alabama. I wonder why they wanted that in 1967, right? And the Supreme Court said, no, you can't subpoena these lists of members because that will have a chilling effect on people's willingness to join these organizations. And they have a constitutional right to free association, free speech, public assembly, all the rights that are protected. Well, what we have learned, it was true when Smith came out, but it's even more true now, is that this CPNI, Consumer Proprietary Network Information, Customer Proprietary Network Information, particularly with the tools that we have now, we can fine-tune, based upon our analysis of that, everything we need to know about you. We can know who your relatives are, who your friends are, how close your friends are which are the friends you talk to frequently. Because the metadata isn't just you called this number, you called this number, you called this number. It's what sequence you called them in, how long you were on the phone with them, and things like that. So you can learn a tremendous amount of information that is protected by the First Amendment simply by having this data available. The next question is, does it make a difference that the data is in the hands of the phone company or the hands of the government? Certainly, Google, through analyzing your emails and analyzing your search history, knows more about you than the NSA does. All right? The TransUnion knows more about you. Every time you use your credit card, there's a record that you used it, what you bought, the date, the time, down to the millisecond of when you used the card. So there's a tremendous amount of personal information that's collected about you by consumer agencies, by commercial entities, by ISPs, by phone companies, and they use them for the mundane purposes of making a buck. Why shouldn't we give the NSA the authority to use that same data for the purposes of keeping us alive and protecting national security? And I think I'm with David on this one. The answer is we should, with appropriate safeguards to protect privacy and civil liberties. Now, I'm going to give you a bit of good news. The bit of good news here is that there are, within the Justice Department, within the NSA, within the Department of Defense, lawyers and others who are dedicated and committed to civil liberties, who really take this stuff seriously and really are trying to protect civil liberties. Okay? On the other hand, you have this problem because you have a mission. And if you look at your mission to, you see your mission as being higher than the need to protect civil liberties will fail as you try to protect your mission. Right. Now, I also want to talk about what happened in the Jones case. In the Jones case, the government put a GPS recorder and transmitter on the bumper of Jones's car. A little known or little observed fact is the government had a warrant to do that. All right? The problem was they didn't attach the device to the bumper within the 30 days specified in the warrant. They did it on the 32nd day because they couldn't find the car. All right? So they attached it 2 days outside the scope of the warrant. Mr. Jones was not a very nice person. He's a major drug dealer in the District of Columbia. They tracked where the car went. And this gets to the question of civil liberties and data collection because Jones is driving around on the public streets. They didn't need a warrant to follow him around as he drove around the public streets. This is publicly accessible information. And the Supreme Court, on property grounds, ruled that they invaded Jones's property when they placed the device on his car. And therefore, it was unconstitutional. But the important part of the decision was what Justice Sotomayor said in the decision, and she said, we really need to revisit this question of third-party doctrine. And so I think within the next 3 to 5 years, we're going to have a decision on the third-party doctrine. There was another significant case, not last year, but the year before, where people had sued as a result of the precursor to the Section 250 program, the NSA program. There were lawyers who said, look, you've intercepted our communications with our clients. And that's unconstitutional. And the Supreme Court said, you don't have standing to sue because you can't prove that your specific communications were intercepted by the NSA. And he says, well, we need discovery. We want the NSA. When they went to get discovery, the NSA said, we can't tell you. And so it was one of those things like, you can sue to find out. If the government doesn't tell you, you don't have standing to even have the suit because you can't prove you were listened to. And this presents that catch-22. So that's another problem here. And then the consequences of putting this metadata program into Section 215, some of which David addressed. Number one, there's a question of what constitutes collection. And this is a problem both for the law and for technology. So if I search a database for certain criteria, okay, and I find people who meet that criteria, let's say I have a database of 1 million records, I search for something, and I come up with 6 hits. And then I read those 6. Have I searched 1 million records without a warrant? Or have I established probable cause to search the 6? And an analogy can be made with dog sniffs. There was a Supreme Court case called Cabreras versus Illinois. And what they did is they had a routine traffic stop. And at the routine traffic stop, they used a trained dog to sniff the car. And if the dog did whatever the dog does when it sniffs drugs, I don't know if they bark, if they sit down, whatever it did, it indicated that there were drugs in the car. They would go search the car and seize the drugs. And the Supreme Court said that that was constitutional because, A, you have no constitutional right to possess contraband, and drugs are contraband, and it was a limited and non-invasive search. Okay? That's what they said. So imagine now the NSA coming up with something that will read every email and only alight when it finds something that's criminal. And this goes to the whole question of, are automated searches or sorting or reading of files where no human reads it, and then it finds stuff based on criteria, in this case approved by the court, is that an invasion of the privacy of the people whose records are not checked for by a human being? And so one of the things the NSA says is, until we read these records, until the human reads them, there's no privacy implication. And I question that. The second is the way they sort of change the definition of relevance. If we can look at records that are relevant, we can retain records to search for relevant records later on. Okay? So they changed that definition. Changed the definition of collection to meaning look at. They changed the definition of relevant to mean might lead to records that are relevant later on. And so these are ways that we sort of perverted the law and the meaning of words in order to get at what we wanted to get at. So those are all things to consider as we move forward in trying to develop a program that will both more accurately define what we want to be able to do and protect civil liberties and privacy while we go forward.
So just to touch on a couple points, Mark raised and a few others. With regard to this last point about collection versus access, it was certainly the board's view that, at least the majority of the board, that collection is a significant privacy issue, even if only a computer sees it or it's sitting in the files of the government, having citizens know, as I said earlier, that the government is collecting this massive information about people does raise concerns, and people have already adjusted their behavior accordingly, which I think is proof of that. Yes, only a handful of the records, a tiny, tiny percentage, are ever actually looked at by a human being. I don't think that undermines the concern. And I think part of it is, for those of us who were old enough to be around in the 20th century and see some political developments, that was a time when the government was misusing information to spy on anti-war activists, civil rights leaders, Martin Luther King Jr., and others. And so we think of now as the government as being more benevolent, but that may not always be the case in the future. And having the government have access to transactions of citizens that can be used for both proper and improper purposes is very troubling, especially when alternatives are available. And another thing about the principle of bulk collection is, yes, the government was applying it to telephone records, but similar arguments could be made with regard to financial records. Terrorists use credit cards, and so that might be information that's relevant. Travel records, location records. And so if you think of the government collecting not only phone records, but also records of other parts of the transaction, then they have almost a complete picture of what you're doing, who you're interacting with, where you're spending your money, and that raises very significant both privacy and civil liberties concerns. Just to talk about the metadata briefly, someone did an experiment to show why metadata was very revealing. They went back to the Revolutionary War period and looked at everybody's associations among the Americans during that time and drew a chart of connections. And surprisingly, maybe not surprisingly, Paul Revere jumped out as having the most connections to different groups. And so even just the mere fact of associational memberships and things of that sort can reveal a lot about people's interactions. You can also go, there's databases.
I just want to point out, the British actually captured Paul Revere on the night of the famous ride, and they let him go because they didn't know who he was.
Right.
Right.
If they'd had that database, they would have detained him. And who knows where.
And what would have happened at Lexington and Concord?
We'd all be speaking with a British accent now, I guess.
Governor? That's right. By the way, the end of the story in Jones was when the Supreme Court ruled it was unconstitutional. The government went to the phone company and subpoenaed his location data from the phone company and then argued, well, now even though it was illegal for us to get it that way, we got it this way, so no harm, no foul. So he ends up in jail anyway. Yes, he does.
Yes. Just to answer at least the question about Mark raised about whether it makes a difference to have the information with the telephone company or the government. And again, I would assert that the government can do a lot more. Yes, the phone company may sell it for marketing purposes, and yes, we don't want to get those calls or emails. But the government can audit your taxes, can put you in jail, do a lot more significant things to you. And so I think there's a very big difference between having the private sector hold the information and have it mediated some way than having the government maintain it all. Also, I wanted to touch on hops for a moment, just because to talk about how this program works. The mechanics are that the government finds a suspicious phone number. It could be a phone book found in a cave in Afghanistan, and they put that number in the system, and they find that I have that number, and I called Mark. That's the first hop. Then we want to know, okay, who are all the people that Mark called? Because if the theory is there's a terrorist plot underway, and he's in the United States, then he might have some co-conspirators that he's working with. And so it'd be very interesting to find out not only that I spoke to him, which is very revealing, but also who he spoke to, so maybe we could start getting a picture of what went on. Of course, if he happened to call Pizza Hut, that raises another question, which is then you go next hop, which is not only who I called, and then who Mark called, but who the people Mark called. And that's the third hop. And you can imagine that creates exponentially larger numbers. And while there may have been a legitimate connection between me and Mark, and a possible connection between Mark and the next step, the third step out is a very tenuous connection and results in gathering up millions and millions of phone records that could go into a large database that are very hard to make an argument that they're relevant to an investigation of terrorists. And so one of the things that the board called for is immediately going from 3 hops to 2 hops, again, because it's hard to justify collecting that much information in that tenuous environment. And so I'm happy to.
And one other thing also.
Sure.
The court approved the program, not the individual searches, and that is a critically important thing. The court approved the mechanism of conducting the searches once you obtained it. It says you have to meet the following criteria. But what the court didn't do, every time you wanted to query the system, you didn't have to go back to apply to the court for another search. And so what this does is raises a specter of what is called a writ of assistance. And a writ of assistance is prohibited in the Constitution. And under the writs of assistance, essentially what would happen is the court would authorize what was called a writ of assistance to the local magistrate or the customs people in Boston. And then the head of customs in Boston would then use that writ of assistance to search for anybody who he thought was hiding goods that were subject to taxation by the crown. So he could use that writ of assistance, which was a general warrant, to go to anybody who met those criteria. The way the program was set up, we took in all of the data. The court approved the taking in of the data through the subpoena, and then a search warrant, actually it was a FISA warrant, and then set up criteria under which you could search. But this would be like the government getting a warrant that said, anytime a police officer smells marijuana from inside a house, he is authorized to enter that house to search for drugs. The criteria may be appropriate. If you had gone to the court each time, they might have issued the warrant, but there's no specific warrant each time you conduct the search.
Although, when President Obama spoke in January about this program, he called for a shift, which is to require the court to approve every search, and the administration went into court and asked the court to reform the process. So now Today, every request has to be a court approved. And in the proposal that President Obama made this morning, even in the future, if the legislation is adopted, requests to phone companies would also require case-by-case approval by the courts. So we shift over.
And that's an area where technology can actually help. Because in the old days, if you wanted to get a warrant from a court, you typed up a piece of paper, you swore an affidavit, you drove to the courthouse, you handed it to a judge, the judge read it, he approved it, he wrote out a warrant. Now you can do this by text message. You can do this by phone call. You can do this by fax. I mean, there's lots of technologies. So the excuse of, hey, I couldn't get a warrant, can disappear because of the use of new technologies.
So, you've heard quite a bit of detail here on issues of the way information is collected and potentially used for purposes of security. Many of you who've worked on issues of big data collection, data mining, inference, hopefully you've made a connection in your own mind as to how your technology could be used, but raises some interesting questions of policy and law. We have about 20 minutes here. If any of you have some questions you'd like to ask of either or both of the gentlemen on the dais there, please step forward to the microphone and ask away. We're going to make sure it's on.
Thanks. So I thought there was an interesting gray area here where, let's say that I'm a bank and I'm getting, or let's say I'm the owner of cars.com, right? And I'm getting hit by a lot of fraud. So I would want to involve the FBI because it's damaging my reputation, et cetera. And that happens all the time, and I think people assume that would be a reasonable thing to do. But let's say I'm Google and the NSA gives me $100 million to catch terrorists for them, and then tell them about these things so that they can put people in jail. So that's kind of that definitely sounds kind of creepy. But then there's a broader gray area in the middle where you could kind of deputize someone to do the work for you, and I'm kind of curious what your take is on that.
Well, I mean, the current structure is not having the government deputize people, but having the court order under a number of legal authorities, companies to provide access to their records. So I think if the government were to actually deputize a private sector firm to engage in activities, I think that would raise legal and constitutional concerns because they essentially become acting on behalf of the government, almost like a government contractor. And I think
violating their own privacy policies.
Yeah, right. So I think that would be a concern, but I think that's not. I mean, the issues that have been part of the public debate are where the government goes to a court and the company is ordered to do it. The company, and then just as a matter of law, has to comply with those court orders.
We do have areas where we have deputized private sector. For example, internet service providers, including Google and others, are required to scan email for child pornography. And if they detect child pornography, to report that to the police. So there are requirements for scanning for child pornography and the like. And we provide them with MD5 hashes of known child pornography for them to search for.
Apologies to many here who have heard it from me before. Because of my background, I have very serious doubts that privacy exists, that any amount of talented work like by you two and many others can, in principle, prevent the government from doing whatever they want to do. Now, it's very good to have a free, democratically elected government and checks and balances and this and that. This is not the Soviet Union. Last I heard, I didn't hear the president's speech this morning.
The president said that the Soviet Union isn't the Soviet Union. I think that was his speech.
Yeah, well, he's an intellectual like all of us. Do you believe, am I putting you on the spot? I'll retract. I wonder whether anybody believes that it is possible to tame the government, that it's possible to prevent the government from doing whatever they want, or are we just raising the ante?
Well, let me take a quick, the fact that David exists, and not as a human being, but in his title, is one evidence that it is possible. But more than that, there are a couple of things. First of all,
How is it evidence?
all right, well, that they've even created such a board. But let me go a little further. There are some structural things you can do to limit the government's ability to invade privacy and civil liberties. One of which is you have a strict separation of ownership. Okay? If the data is held by and owned by an entity that has an economic interest in keeping it private, safe, and secure, you've created at least a structural barrier to the government's ability to invade privacy. And one of the things we're seeing as a result of the backlash on the Section 215 program is a move by companies all over the world to start encrypting data using technologies that they hope the government will at least have a hard time decrypting. It increases the barrier to invasion. The second question, when you say, can we prevent the government from invading privacy, is really more of a metaphysical question of what do we mean by privacy. And generally by privacy, we mean that data privacy, that data is collected and used for the purposes for which it's collected, is used for the purposes for which it's collected, and protected against use for other purposes. And so it's not inconsistent to me to have Google know everything about me and tell the government to go pound sand. So I think we can, but if you have a brutal, dictatorial, and controlling government, nothing can prevent them from if you've got a gun, you've got my data.
Well, I meant the U.S. government.
But the point about it is, if the guy you're trying to get the data from doesn't have the key, and there's no feasible technological means for the government to easily get that data, you've created a structural barrier.
Well, a lot of us here know what encryption is really worth.
It's worth something. It's just not worth everything.
I just want to address that as well.
Sure.
I mean, our board is premised on the notion that there can be some oversight and accountability for the government. I've been doing it less than a year, so time will tell. But I think first of all, as Mark said, the fact that we exist, that we have full access to government programs and can say what we think about them, it's important that we can shed light on what's going on. Each of the agencies have very rigorous compliance programs. There are inspectors general, there's congressional oversight. And I think, there are a lot, we can debate if the last couple of months have been better or worse, but they certainly have shed a lot more light on how these programs operate, and I think have made people in the government a lot more accountable, both legally and as a matter of policy.
There's a second half of what David does, which is the advice part, and that tells him whether and how to protect privacy. And a lot of it is about inculcating respect for privacy and civil rights, understanding of what privacy and civil rights means, and inculcating respect for privacy and civil rights into the organizations themselves who are not used to thinking that way.
Yeah, that's a very important part of what we do that will probably not be public at all, which is where we go in a classified setting and we give privacy and civil liberties feedback, and hopefully programs will be revised if necessary to adjust those concerns, and they'll never be a problem. We've already done that to some extent. We've been called into agencies and asked to look at very highly classified programs and have given our feedback, and we hope to do that more. One area where I expect to do it is there are guidelines that each of the agencies have to operate that are approved by the Attorney General, and we've both critiqued that process and said some of them are more than 30 years old and need to be updated, but we've also said we want to help you update them as well. And so we want to be partners and trusted, but also maintain our oversight function, but take very seriously our ability to help shape programs so that they respect privacy and civil liberties from the beginning.
And I want to tell you one other thing about the commercial sector, completely apart from your question, but related to it. So I read the other day that I think it was General Electric came out with a smart air conditioning unit. And the smart air conditioning unit would turn itself off when you left the house. And then when you were a certain distance away from the house on your way home, it would turn itself back on again so you could come home to a nice cool room. But you don't have to worry about that if you live in West Lafayette, Indiana. So It's a great idea. I'd love to have one. It saves money, saves energy. The air conditioning unit is only on when I need it, all that stuff. But in order for it to do that, it has to know when I've left, what direction I'm heading, that I'm just not going around, and not only how far away I am, but I'm on my way home. So it has to collect a massive amount of data about my normal behavior and things like that. I got no problem with it doing that for the purposes of saving me money and turning my air conditioner off, but it's a massive amount of data that has to be collected, analyzed, and protected. And one of the problems you have is we have to think as we enter big data in any area. When you're watching TV, is your TV watching you? And you have to worry about how do we collect data in a responsible, appropriate way. The government has to think about it. Private sector has to think about that.
Chris?
Yeah. First, kind of just one other point on this. I think just the fact that that a previous version of David's board was reconstituted by Congress after it proved to be ineffective shows that there is some hope for our government. Otherwise, they would have left the ineffective board there.
I think to me, part of the point is on January 23rd, we issued our report saying we thought the 215 program was not statutorily authorized. That very same day, the White House said we disagree. But I think it shows that we are able to disagree with the White House and draw our own conclusions about these programs, and then we can have a national debate about the pros and cons.
Yeah. But the second thing is related to this. One of the big issues here is how effective are these programs? That was one of the interesting points in the report was, has this been effective? And if everybody felt it had been very effective, I'm sure the outcome would have been very different. But now how do you apply that to a court getting a request to approve the collection of information? How do you judge whether it might be effective or is likely enough to be effective to justify the potential privacy risks?
Well, and there's another point about that too. When you're actually, let's start with the first thing. The government says, if not for this program, we wouldn't have caught these following 6 people. Well, first of all, how do you measure the cost and benefit, and how do you value the cost? And then you say the program was effective. You have to say compared to what? All right, and that's one of the problems. Is there a way to do this to achieve same or similar results with less invasion of privacy, more respect for privacy, and more civil liberties? And you're not going to get to that question unless you ask it. And I think one of the things David was talking about is to say, does it matter if we get the phone? Most of the time, we're surveilling somebody we already know and suspect to be a terrorist, and we're trying to find out what they're doing, not to identify somebody who was not on the radar in the first place. And for that kind of person, does it matter if we get the records in minutes or hours or days or weeks? Does it make a difference? So you have to compare it.
I want to break your question up into sort of a policy question and a court legal question. Because you asked how is a judge going to make that determination. I think it won't be often that a judge is asked to make a determination on a whole program, whether it's effective or not, if the judge is even asked that at all, because usually Congress would either authorize it or not. But I think if a judge were put in that situation, I think that highlights the importance of having a different voice in the courtroom besides the government's voice. Because if the judge wants to assess efficacy and other policy issues, I think you need to have someone arguing for citizens. And that's why we recommend that there be a special advocate in the court who can argue the other side of that. But I think the efficacy question is a very challenging one. And as I said, we looked at 7 or 8 factors as to what could make a program effective. Finding other co-conspirators, thwarting plots, peace of mind, things of that sort. We are now turning to the 702 program, which is the PRISM/upstream program. And we're also going to assess effectiveness of that, but we may well apply a slightly different set of criteria depending on the nature of the program. And one of the things that one of our dissenting board members called for is for the government to establish some criteria for what constitutes efficacy. And so again, we can have a debate about that. But programs can be effective in many different ways. If they inform the policy debate, if they marginally help get bad guys, if they thwart plots, there are a lot of different ways. And I think we should think it's a much more complex undertaking than a very simple top-line question.
But you also have to measure things like the chilling effect on people's civil liberties and the chilling effect on U.S. companies if people know or suspect that U.S. companies are complicit in acting as agents for the NSA and then abandon their products and services for some other company that does the same thing, it's just that we don't know it.
So I have a question that's based on some things that I've seen speculated about and might be interesting in some regard here, that if I'm charged with a crime and as an attempt to prove my innocence, I want to show that either that I never contacted the other parties involved, or I would like to show there's reasonable cause to believe that somebody else was involved in the contact, and have a subpoena issued for the federal records for them to do this search.
Right.
My understanding is that if the government agency fails to provide that, that provides some cause for actual dismissal of charges.
Yep.
I'm not a lawyer. I didn't stay at a Holiday Inn Express. So, but if you could speak to that general issue about any of these large collections of data, private or government particularly, some of the side effects of seeking that information for other causes. I'm trying to see where my children went, my spouse went, my business partner.
Well, first of all, if you're charged with a crime and you're trying to prove your innocence, you're doing something wrong. It's the government's burden to prove that you're guilty.
I didn't learn to hire you, Mark. I'm sorry. It's
So that's the first thing. All right. So the main case you're talking about is a case called Brady versus Maryland. And in Brady, the government has an affirmative obligation to disclose to a criminal defendant any material information that goes on the issue of guilt or innocence or the impeachment of the credibility of a government witness. The problem with Brady, so let's take a situation where the government has collected, instead of phone records, location records. You're charged with a crime. The FBI has information that you were at a particular place, committed a crime. Meanwhile, the NSA is retaining a location data that indicates that at a minimum your phone and more likely you were not present at that date and time. So the first thing is, do they have an obligation to turn that over to you? And the answer is, unfortunately, probably not, because the FBI will claim, most likely, we didn't know about it, and only certain agencies come under Brady. But let's assume that the FBI does know about it. If they know about it, they have an obligation to disclose it. So the government doesn't have to search the databases of every government agency to look for Brady information, but if it's aware of the Brady information, it has to disclose it. Second part is, now you subpoena the records from the NSA, and that's what we're seeing much more often. They go to the phone company and say, hey, I'd like my telephone toll records and my location records. The phone company says, we only keep them for 18 months. They're gone. Sorry. You say, but the NSA keeps them for 5 years or longer, and they subpoena the NSA. And that puts the NSA in a real quandary because they don't want to admit that the stuff exists. So what the NSA has been doing is either saying, we don't have any records that comply with your request, or they say, they evoke what's called the state secrets privilege. And when the government invokes the state secrets privilege in response to a request for exculpatory information, there are going to be circumstances where the government is going to be forced to dismiss a criminal charge not because it can't prove the case, but because it cannot disclose the exculpatory information. There is a statute called the Classified Information Procedures Act, CIPA. CIPA does allow the government to go to the court and say, look, court, this is what we've got. So it may be able to invoke that from time to time.
Yeah, I mean, it's a very tricky issue. Because if I can go to the government and say, do you have records on me?
No.
That could obviously be damaging to national security. And so it's a very tricky situation. One thing is there has been a change in government policy now. If there are criminal indictments, at least for some of these surveillance programs, the government has said we'll start disclosing where we got the information, which I think is going to ultimately set up a Supreme Court case to resolve the legality of some of these programs.
And what David's talking about is where we got the information. So what would happen would be, we would, in the national security arena, learn about a drug cartel and a truck laden with drugs coming across the border or driving through Texas. The NSA wouldn't provide that information to Customs and Border Patrol. They would say, look out for this truck. There's a license plate. It's going to be on this highway at this time. The Border Patrol would then follow the truck and wait for it to change lanes without signaling. They would pull it over for changing lanes without signaling, then search the truck, find the stuff that was inside. And here's the tricky part. When they got to court, they would testify under oath. The reason I pulled the truck over is because it changed lanes without signaling, when in fact the reason they pulled the truck over was because they were told to by the NSA. Or alternatively, they would apply for a warrant, and instead of saying the NSA picked this guy up on the classified wiretap, they would say a confidential informant told me that this guy was doing it. So they were either lying to the court or deliberately misleading the court. And the scary thing is, when that program was revealed, the Border Patrol, the DEA all said, we do this all the time.
Coming up for questions? Okay, well, come on up to the microphone. Yeah, come up to the microphone if you're going to ask a question. We'll take you two, and then we're going to have to call an end to the session.
Okay. Last month on C-SPAN, there was a session where they were looking at the global security threats. There's probably about 10 senators on the panel. They had the director of the CIA, the director of the FBI, the director of NSA on there as well. And they're kind of drilling them for, not being able to get the information like they had requested previously. But when they got to metadata, Senator Rockefeller said that the telco companies didn't want that responsibility. They don't want that data, in his opinion, and that the NSA was more talented and able to search that data and had the expertise as opposed to the telco companies. What are your thoughts on that?
Well, we concluded, at least the majority of our board concluded, that there are techniques for searching the phone company databases that could be just as effective as maintaining the bulk data. As you know, the president in January, or you may not know, but the president in January called upon the Attorney General of the United States and the Director of National Intelligence to conduct a study of possible replacements for the 215 program. And again, that's what was revealed today, which was the recommendation was to go to the telephone company. So that was not only our judgment, but the judgment of the Attorney General and Director of National Intelligence that we could be equally effective going to the phone companies. Again, I think it's largely a technology issue, and we have great database search abilities now and high-speed communications. And so we're not searching 1,000 databases, we're searching a limited number of databases, and it seems as though there ought to be a mechanism. Particularly, there have been some proposals to standardize the information across the phone companies, which would even facilitate further the ability to search effectively and quickly. So I guess my view is that you don't have to have it in one place.
I would only add that, so it's not efficient, you can't do it. Too bad. You know what I mean? There's lots of things. The government can't go to one database and find out everybody's medical records and say it might be useful, it might be helpful, and they may have some legitimate reasons for doing it. But the point is, the phone companies collect these records so they can bill you for them. And the fact that it's not their process for collecting and storing and keeping them isn't convenient for the government, too bad. That's not why we created them. That's my philosophy. And that's the difference between private records created for private purposes, you take them the way they are, and records created for the purposes of the government.
I've got two questions. Maybe you can help me. The first one is, many of the older people, grandparents, are learning how to use computers, emails, and do all kind of electronic exchange of information. Is there any way that they can be protected because they're not fully into this internet business? They're just trying to communicate a little bit with their grandchildren on YouTube or Skype or something like that. That's my first question. The second question that I have is more interesting. Can any one of us, and I think the question is to any one of us, find a way to confuse the Google or the NSA on a daily basis? So I'm not the same person with the same email, with the same phone number, with the same social security number every day or every hour. And so basically, they're tracking me and I want to confuse them. So for example, in the case of that car,
Yep.
putting that thing, I don't drive that car every day. I drive 30 other cars.
Every
what can
other
I-
day I surf as you, so that keeps me.
What can we do to make their databases so noisy and confusing they can't get anything out of it?
Well,
Two questions.
the answer to the second question is, there are things you can do to make it more difficult to be attributable. None of them work very well, okay? And none of them work consistently, and none of them are applied consistently, and people make mistakes. And the answer to the first question is no. You're lucky that grandma can send an email. Be thankful for that. That's it. I mean, look what Jimmy Carter said. He says when he wants to send something securely, he sends them a snail mail letter, which then they have to actually steam open to read before they reseal it and let it go through. So what we're seeing is that private companies are starting, and we protect its privacy and security, you have to ask yourself, from whom? If we're trying to protect it from hackers, are we trying to protect it from the government, or are we trying to protect it from Google itself? So from Google itself, nah, you gave that up long ago. You want to protect your email from Google? Use Hotmail.
I guess what I would add is that I wouldn't lose sight of the fact that the NSA does protect us from very serious threats, does thwart terrorist plots on a regular basis. One example, which ended up not being a 215 example, but a 702 example, the Zazi plot, where Mr. Zazi was going to New York to bomb the New York City subway system. And the NSA intercepted communications that led our ability to thwart a plot where people would have died on the New York City subway system. So the notion that there's some virtue in everybody avoiding, including the bad guys, avoiding detection by the NSA has consequences. Again, obviously we exist to say that there should be a balance between national security and privacy and civil liberties. But let's not lose sight of the fact that they perform a very serious, important function to protect the country at the same time.
I'll just add as a closing note here, for those of you who are interested in this, certainly there are a number of documents that have been published that are available on this. There are various organizations that follow this carefully. And if you look back in our online archive of talks from the Wednesday seminar series, about 3 weeks ago, Professor Ed Felton of Princeton gave a talk on some of the statistical issues of analyzing information in large databases that may further illuminate this topic for you. In the meantime,
I would also commend our 235-page report on the 215 program, which is at pclob.gov if you'd like to read it.
So please join me in
I would
thanking
commend 234 of those 235 pages.
join me in thanking our two speakers today. Thank you.